choose. Recorded live.
I'd like to welcome everyone to this Wednesday, January 29th, 2014 edition of Money Banking and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. Welcome to the revival of the study of equity, its principles, doctrines, and rules of equity in opposition to the tendency giving an undue prominence and superiority to purely legal rules and ignoring, forgetting, or the suppression of equitable notions. And welcome to Repent, for the Lord's Kingdom and its enforcement is near. We left off in John Norton Pomeroy's Equity Jurisprudence, Volume 3, 1918 edition, on Section 1018. That's page 171 in the PDF or page 2264 in the book. Just started Section 4, Public or Charitable Trusts. That's Section 1018 under General Descriptions. So take notice and acknowledgement with agreement that this show under documents is a private confidential arrangement not to be construed or relied upon as being legal advice for any individual legal situation or employed for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and our documents are for academic and informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given any legal advice or accepted fees for legal advice or provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in preparation or use of herein referenced, and has no interest in any use referenced here therein, and is not a party to this or any action arising from, and is only acting as an authorized capacity as liaisons to communications between the parties. By reading or using this information, you acknowledge and agree you are not a client of Christian Walters. These documents and their show recordings are incomplete and void without this notice agreement being attached herein by reference in a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for commercial damages of $200 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding. So now on to a definition of equity, what equity is, and I can't think of any other definition as spelled out by John Bouvier under the Institutes of American Law of 1882, Volume 2, Section 3724, Paragraph 4. That Paragraph 4 states that, quote, law is nothing without equity, and equity is everything, even without law. Those who perceive what is just and what is unjust only through the eyes of law never see it as well as those who behold it with the eyes of equity. Law may be looked upon in some manner as assistance for those who have weak perception of right and wrong, in the same way that optical glasses are useful for those who are short-sighted or whose visual organs are deficient. Equity, in its true and genuine meaning, is the soul and spirit of the law. Positive law is construed, rational law is made by it. That's John Bouvier, Institutes of American Law, 1882, Volume 2, Section 3724, Paragraph 4. So equity in its true and genuine meaning is the soul and spirit of the law. Positive law is construed and rational law is made by it. If it's the soul and spirit of the law, then it's really equity that creates all law. And equity, there is no other law higher than equity, because equity is really God's law. And this spirit, this soul, the actual principles and doctrines of equity, and that is, by definition, what's fair, just, and right. And this fair, just, and right, this spirit and soul of the law, this equity principle, is what creates all of the jurisdictions of law, whether it be admiralty, common law, civil law, I don't care what jurisdiction you want to call it. It was all created by one thing, equity. Equity is the soul and spirit of all law. Whatever positive law there is construed by it, and whatever rational law there is made by it. It is the highest law in the land. It is the highest law in the world. It is the highest law in creation. It's God's law. Remember, it doesn't matter how many people don't believe it. What matters is whether it's true or not. Believing a lie does not make it true. Be careful what you trust in. And now my pet peeve, public versus private. Everybody stumbles with this. This is a stumbling block. Everybody thinks what's private is really not private. It's public. They just don't know it. So we need a definition of what private is. And private is any relation that you imply or express which is your intent as a special one. And the next question I'm going to ask is, when did you ever express with your intent to form any relation as a special one? And the answer to that is never. So consequently, all your relations then are all public by default, and you just don't know it. But the key is this special one. How do I form this special relationship? That's NTT in a whole nutshell. That's what we've been talking about for the last 4 years. New trust technology, which relies on equity being in its jurisdiction. NTT, or the special relationship, private trust. In other words, that's what we're talking about. Private trust, that's a special relationship. How do we form a private trust? If you didn't form a private trust the way a private trust is recognized, then you don't have any private relation. You have a public relation. That's the whole key. Pay particular attention to the relationships you're forming moment by moment, day by day, hour by hour, especially when you're signing your name. Are you forming a special relation, or are you forming just a general relation, just a public relation? And that brings in the doctrine of election then. When you have two or more things to choose from, the thing that you choose substitutes for all the rest of them, or you waive the rest of them. See section 463 in Pomeroy. So if you didn't express your relation to be a special one, then all your relations are all public and you just don't know it. So don't think that you're having a private conversation between your neighbor across your fence in your backyard, and that's a private relationship. Because if you didn't do anything special to create a private trust at that moment, there is nothing other than a public relation that you just formed. Now that goes against what most people think. All I got to do is express it to be public to say this is a private relationship. No, afraid not. That doesn't cut it. And why doesn't it? Because your intent. How do you demonstrate your intent that this was a private relation? In other words, how do I form a private trust again? Well, now we go to LGVA versus Belvedere Farms. Now, that's a 2011 case. That's out of the Court of Special Appeals of Maryland. It's referencing Austin Wakeman Scott, which is Scott Law and Trust, and William Franklin Fratcher at section 2.8. And this case, which states, quote, "It is to be noticed that an express trust may arise even though the parties in their own minds do not intend to create a trust." Now that brings in trust law, because trust law states that no party in a trust needs to know or a trust is being formed. And really that's the restatement on the law. And that's kind of hard for people to grasp, because how can I be forming a trust but not know I'm forming a trust? It goes on in this case to explain that in a way. It says, it is the manifestation of intention that controls and not the actual intention. So the controlling thing that determines whether or not this is really a trust is the manifestation of intention. And just exactly what is the manifestation of intention? That is a record or a deed. And there's only this false notion of what a deed is. You think the deed is a piece of paper that's the ownership to the thing or property, collateral. And really it's not. It's just a record of the act that was done, your actions, written down on a piece of paper and then recorded. Or maybe it's not recorded, depending on the circumstance. But it's that document, that record, that manifests the intention. And that's what the court looks like as the controlling document, the record. That's why you cannot understand that it's not the actual intention. Now, that's the actual knowledge of knowing that you formed a trust. It's not the actual intention. You don't have to have actual knowledge. No party in a trust needs to know a trust is being formed. It's the manifestation of intention that controls it, not the actual intention. Where that differs from the manifestation of intention. An express trust may be created even though the parties do not call it a trust, and let's put it this way, even if they don't even understand what a trust is, which is what the next part says, and even though they do not understand precisely what a trust is, it is sufficient of what they appear to have in mind is in its essentials what the courts mean when they speak of a trust. So, when does a trust form? Well, there's two theories as to when a trust forms. One is when you transfer a res in the hands of the trustee, and another is at the moment the grantor, in his own mind, created a duty for one party to take care of a thing for the benefit of a third party. Now, that doesn't sound like a trust unless you understand trust doctrine. Because you've got intent, you've got purpose, which is a duty, you've got parties, you've got a grantor, you've got a trustee, and you've got a beneficiary, and you've got specific trust res, something that's identifiable to be for the benefit of somebody else. So, even though you do not understand precisely what a trust is, it's sufficient of what we have in mind here, in its essentials, what the court speaks of when it speaks of a trust. And it speaks of a trust according to a trust test, which is those 5 things that I said. Intent, number 1. 2, purpose. 3, parties. And there are 3 office heads in a trust, and that's all. And those 3 office heads are grantor, trustee, and beneficiary, and that's all. There are no other office heads. There's no executor in a trust. Just those 3. Grantor, trustee, and beneficiary, no others. Those are the primary relationships. Every other relationship with that is a secondary and doesn't pertain exactly to the trust itself. So you've got 1, 2, and 3, and then number 4, specific trust res identifiable. And some method of formation, which would be, this doesn't really form the trust, but it's the transfer or delivery of trust res, say. And that doesn't have to be actual transfer. The actual transfer happened in the grantor's mind when he was planning on giving the trust res to another party, the trustee, who had a duty for this other third person, the beneficiary. So as long as those 5 elements are there to fulfill the trust test according to the courts, then what you have in mind is essential a trust, even though you don't even know you formed a trust. You don't even have to say, granted to T in trust for B. No term controls. no specific expression, to create. It's when a duty is cooked up in the mind of someone for somebody else to hold a piece of property, to do something specifically with that party for that property for the benefit of someone else, a third party. That's a trust. So that's the manifestation that it controls. You've got to have some kind of records. Records to demonstrate the intent. Now back on to Adams' quote and the origin of English equity, where Adams wrote, "We may confidently assert that equity and common law originated in one and the same procedure. That during the first 200 years of their history, they were not distinguished from one another." In other words, they were separated. They were distinguished apart. But we just never realized that. Equity and common law were one and the same back in the old days. Not distinguished from one another. But they are separate. Keep in mind the Bouvier quote that I quoted just a little bit earlier. Continuing on, not distinguished from one another, and that if we now distinguish between them during that period, we do it artificially by the application of tests if possible to contemporaries. It is well on into the 14th century before we get any clear distinction between equity and common law. In other words, people finally realized that the two were separate. Two separate things. Remember, Bouvier says that it's equity running the whole show. Equity created common law. Equity, by definition, is what's fair, just, and right. And if you ask the common law people, they say, what are we looking for? We're looking for what's fair, just, and right. We're looking for that unwritten part. Back then, the unwritten part was the fair, just, and right, which created the common law. And today, everybody's still not seeing the distinction between the two, that they are separate, and one created the other. And that's everybody's problem. They're stuck in common law, but what they really want is equity. Equity is the soul and spirit of the law. Bouvier's quote. They are distinct. And from that rediscovery of the distinction that they are separate, not one and the same, but segregated, separate. That's in the 14th century when we started coming out of the Dark Ages. The Renaissance happened. And everything started to blossom and bloom. And today, we've lost that distinction. We've gone back the other way. And we're re-entering back into the Dark Ages again. And common law, by definition, is the law common to all people at the specific time. And if you apply that definition today, the law that's common to all people is statutes and codes. But what you have to know is that statutes and codes, or the Ten Commandments, are really like the 1/10 judgment side and the 9/10 equity. But you have to keep them both in view, equity and common law, or the statutes and codes. 9/10 is the priority, which is equity, that creates the statutes and codes, or the Ten Commandments. The 1/10. The 1/10 is the judgment side of not doing the 9/10. But just like an iceberg, you can't tell what's below because it's the unwritten part. That doesn't mean that it's not written someplace that you can understand it. It's just not written where it's codified. Because the statutes and codes are written, codified. The unwritten part is really the core, the substance, or the true meaning, the 9/10 that you don't see because it's not codified or written. It's the unwritten part. Equity is the unwritten part of the law because the law encompasses two things: equity, the 9/10 priority, and the 1/10 enforcement of not doing the 9/10, which is the statutes and codes or the judgment side or the 10 Commandments. So you must look at them both as being one. One is the head, the other is the tail. The head being equity, the more important, the priority, the 9/10, the most important part, but that's like the underneath iceberg part that you can't see. And then there's the judgment side, which is the statutes and codes of the 10 Commandments, or the 1/10, which is the enforcement of not living an equitable life. And if you really want to put it down, the law that's common to all people today, as well as it's ever been since history began, since the creation began, has been equity. Because equity reflects the God-conscious mind. And what is that? Well, it's fair, just, and right. And that's what everybody wants. But you got to remember, the first maxim in equity states that he who comes into equity must be doing equity. If you're not living an equitable life, God will not do anything for you. You got to be living an equitable life to get equity to do something for you. That's the same as in the scriptures of Matthew 7:12. He who comes into equity must be doing equity. Is the same as 7:12, which states the golden rule: do unto others as you want them to do to you. This is everybody's problem today. This is the lack of love that's out there. Everybody knows and wants equity to be done to them, but they don't know how to do equity to others. And they need to take the plank out of their own eyes so they can see clearly the speck in their brothers. Forgiveness and mercy comes from recognizing that you have to be living an equitable life to get equity to act for you. Let he who is without sin cast the first stone. Remember, welcome to repent, for the Lord's kingdom and its enforcement is near. This is like the last message before the judgment. Wake up, people. Start living equitable lives. Start living equitable lives and loving your brother as yourself, which fulfills all the commandments, the Pentateuch. And that's how you love the Lord your God with all your heart, soul, and mind. Not by rituals or traditions. Not by the wearing of the mezuzah cap or worshiping Mother Mary. Not that at all. And if we would all live equitable lives, the blessings of God would be poured upon everyone on the earth. You would be living in the kingdom by doing kingdom principles. And you would have basically untied the hands of God to work miracles in your life. Section 1018 in Palmaries. Public or charitable trust. What a misnomer here. Charitable trust. Loving your brothers yourself. In express private trust, there is not only a certain trustee who holds the legal estate, but there is a certain specified sedekey trust clearly identified or made capable of identification by the terms of the instrument creating the trust. It is an essential feature of public or charitable trust that the beneficiaries are uncertain. A class of persons described in some general language, often fluctuating, changing in their individual numbers, and partaking of a quasi-public character. The most patent examples are the poor of a certain district in a trust of a benevolence nature, or the children of a certain town, but the children of God. In a trust for educational purposes, in such cases, evident that all the beneficiaries can never unite to enforce the trust, even if those in existence at any given time could unite, they could not include nor bind their successors. It is a settled doctrine in England and many of the American states that personal property and real estate, except when prohibited by statutes, may be conveyed or bequeathed in trust upon charitable uses and purposes for the benefit of certain uncertain classes or portions of the public, and that if the purposes are charitable, within the meaning of given to that term, a court of equity will enforce a trust. Furthermore, it is often the most important and distinctive features of charitable trusts that, however long the period may be during which they are to last, even though it be absolutely unlimited in its duration, they are not subject to nor controlled by the established doctrines, nor even the statutes which prohibit perpetuities. Indeed, it may be said that the full conception of a charitable trust includes the notion that it is or may be perpetual. Next section, 1019, a public and not private benefaction requisite. In order that a trust may be charitable, the gift must be for the benefit of such an indefinite class of persons that the charity is really a public and not a mere private benefaction. On the other hand, in a public trust, the designation of a charitable use and of the beneficiaries must be sufficiently certain and descriptive to indicate the intention of the donor. The language must not be so general and vague as to leave both the beneficiaries and the purposes and objects completely to the judgment and choice of the trustee or of the court. Footnote 1. Looks like a lot of case sites to support that one. Next section, 1020. What are charitable uses and purposes? Statute of charitable uses. It is a question of primary importance upon which all others depend to determine what uses and purposes are charitable within the meaning of the doctrine, so that gifts for such purposes may be sustained as valid charitable trusts, although they may tend to create perpetuities. It has also already been shown that the purpose, whatever be its particular object, must benefit some indefinite class or portion of the public. For mere private charities are governed by the rules which apply to ordinary private express trusts. The general objects which come within the description of charitable uses, of which may therefore constitute a valid charitable trust, which were enumerated in the statutes of charitable uses passed in the reign of Queen Elizabeth, as follows. Footnote 1. It says the charitable trust now under consideration should be carefully distinguished from gifts to corporations, which are authorized by their charter and other statutes which to receive and hold property, and apply to objects which fall within the general designation of charitable. Such gifts are permitted in the states where the particular doctrine of charitable trust has been abrogated, and they are regulated by the general rules of law applicable to all corporations or by provisions of the individual character. Two case sites to support that. Back into the text. Again, Queen Elizabeth as follows. Quote, the relief of aged, impotent, and poor people, the maintenance of maimed and sick soldiers and mariners, the support of schools of learning, free schools, and scholars of universities, repairs of bridges, ports, havens, causeways, churches, sea banks, highways, education, and preferment of orphans. The relief, stock, and maintenance of houses of correction, marriage of poor maids, aid to help young tradesmen, handicraftsmen, and persons decayed, relief or redemption of prisoners and captives, aid of poor inhabitants concerning payments of 15ths, setting out of soldiers, and other taxes, unquote. It will be seen that this list omits some most important and familiar charitable objects. For example, the support and propagation of religion. The English and American courts have never regarded this enumeration as exhaustive, but has designed to be more merely illustrative, and numerous objects analogous to the mention in the statute are held to be charitable. The doctrine is settled in all particular objects embraced within the general spirit, intent, and scope of the statute are to be considered as charitable unless they violate some rule of public policy or provisions of some positive statute. Footnote 2. As many gifts or purposes confessedly charitable are defeated by the statutes of mortmain in England and in the states where these or analogous statutes have been adopted. Back into the text. Next section, 1021. Classes of charitable uses. Number 1, religious purposes. In addition to the objects specifically enumerated by the statute, other purposes of like general nature are held by the courts to be charitable, and these may be all arranged in the following classes. Religious purposes. The support and propagation of religion is clearly a charitable use. Footnote 1. It says in England, an exception is made of superstitious uses contrary to the public policy, such as masses for the soul. Case sites to support that. It says in the United States, no purposes would probably be regarded as superstitious, which are recognized by any religion, belief, and ritual. Case sites to support that. Back into the text. This includes gifts for the erection, maintenance, and repair of church edifices, and maintenance of worship and support of clergymen, the promotion and propagation of religious doctrines and beliefs that in any manner by the church or by an association, the aid of missionary, Bible, and other religious societies, and all other objects and purposes which are really religious. The English courts made an exception with reference to superstitious uses, but in the United States no such distinction is made. Our courts would recognize no difference among religious beliefs and opinions, but in this country, as well as in England, a gift could not be sustained as a charity for religious purposes when it was wholly irreligious, and its only object was to destroy all religion. Next section, 1022. Number 2, benevolent purposes. Numerous trusts for purposes of benevolence are upheld as charitable, although not mentioned in the statute, since they are within its spirit and intent. Among the particular instances embraced within this class are trusts for the poor and deserving poor, widows and orphans of a specified town, district, or country, for hospitals, asylums, and similar public institutions, for any class of persons requiring aid as the colored persons of a certain state, and benevolent objects, generally who, without specifying the form. Even trusts established for the donor's own poor relations or poor descendants, and as a class, are held to be true charities. The beneficiaries are to be relieved, and the mode proposed for aiding them must be public. A trust on behalf of a strictly private association, the benefits which are confined to its own members is not a charitable trust. Next section, 1023, number 3, educational purposes. Gifts, devises, and bequests and trusts for educational purposes are valid since they are all certainly within the spirit of the statute. This class embraces all trusts for the founding, endowing, and supporting schools and other similar institutions which are not strictly private, for the establishment of professorships and maintenance of teachers, and for education of designated classes of persons, as the poor children of a town, for the promotion of science and scientific study, and generally for the advancement of knowledge, learning, and education. We never looked upon our schools and our universities as being trust. And it's not just them, it's everything is a trust. Because today you can't complete a contract because there's no consideration exchangeable for value. And what is the definition of value anyway? If there is no consideration, how can you complete a contract? But under trust doesn't need consideration to be forming a trust. There's no consideration necessary to form a trust. So consequently, everything is all trust, you just don't know it. But yet we're doing a commercial thing. Why aren't we operating a trust? A trust must be operated as a trust. We're not operating the trust as a trust. We're operating the trust as a contract. And here the contract's only one half of the puzzle. The other half is you got to recognize the contract's not a contract. The contract's two trusts. One trust on one side, the other trust on the other side. Two trusts working in conjunction. Check out Pomeroy's section 366 and 367, executory trusts, the two perspectives, the at-law version and the equity version of equitable trusts, executive contracts. Next section, 1024. Number 4, other public purposes. Other public purposes, not in the ordinary sense benevolent, may be valid charities since they are either expressly mentioned by the statute or within its plain intent. All of these purposes intend to benefit the public, either of the entire country or of some particular district, or to enlighten the public burdens by defraying the necessary expenses of local administrations, which rest upon the inhabitants of a designated region. Isn't that what's happened today? Hasn't the burden been lightened for the public to defray the necessity expenses of the local administration? In other words, so you don't have to do it yourself? They're doing it for you? So you're not doing government, your local administration yourself. Somebody else is doing it on behalf of you because you don't know what's going on. You're still sleeping. You're not doing government. Because if you're doing government, you'd be doing it privately. You'd be leading an equitable life day by day. And you wouldn't need government because you'd be taking care and doing government yourself. You'd be taking care of your own business. I wouldn't need somebody else to take care of my business for me if I was awake. There'd be no public burden for defraying the necessary expenses of local administration which rest upon the inhabitants. It rests upon the inhabitants. It rests upon the people of a designated region. But when they don't do the local administration, somebody's got to do it. It doesn't get done automatically. Somebody's got to do it. It's called responsibility. And today the public is not responsible. They're not living equitably. Responsibility is part of the duty. Next section, 1025, creation of the trust, certainty or uncertainty of the object and of the beneficiaries. One of the distinguishing elements of a charitable as compared with an ordinary trust consists in its generality, indefiniteness, and even uncertainty, which is permitted in describing the object and purpose or the beneficiaries. For the very definition of a charitable trust, the beneficiaries are always an uncertain body or class, but the doctrine goes further than this. If the donor sufficiently shows his intention to create a charity and indicates its general nature and purpose and describes in general terms the class of beneficiaries, the trust will be sustained and enforced. Although there may be an indefiniteness and a declaration and a description, and although much may be left to the discretion of the trustee, this uncertainty, however, must not be carried too far. So let's back up again. When did the trust form? in the intent of the grantor's mind, whenever he came to a conclusion that he was going to form a duty in a trustee, another party, concerning a thing, a res, for the purpose of the benefit of another third party. That was the formation of the trust. If the donor sufficiently shows his intention to create a charity and indicates its general nature and purpose, intent and purpose, parties, specific trust res, and a method of transferring the res, say delivery. If the donor sufficiently shows his intention to create a charity and indicates its general nature and purpose and describes in general terms the class of the beneficiaries, the trust will be sustained and enforced. Picking up where we left off, this uncertainty, however, must not be carried too far. The intention of the donor to create some kind of charity, religious, benevolent, educational, or otherwise, must never be left uncertain. It must sufficiently appear that he designated to establish a charity, and the purpose must be indicated with sufficient clearness to enable the court, by means of a settled doctrines, to carry the design into effect. In other words, if it passes the trust test. And again, what's the trust test? Intent, number 1. 2, purpose. 3, parties. 4, specific trust res identifiable. And 5, some method of formation. That's the trust test. If it passed the trust test, you got a trust. Back into the text, it is well-established English doctrine that the court strives to carry out a charity if at all practicable. In this country, the doctrine has been adopted only to a partial extent, and in a few of the states where the system of charitable trust prevails, the English theory seems to have been accepted with little or no modification. In most of the states, more certainly in defining the purposes of the charity in terms of the trust, or in designating the classes of persons who are intended to be the beneficiaries is required in order to sustain the gift that is necessary under the methods of English court. Footnote 2. Footnote 2, it says it is impossible to formulate any more specific American rule since there is a radical difference in the theories and fundamental views prevailing in the various states. I shall make no attempt to analyze and classify the decisions upon this most important question, but shall simply give some examples, referring to the reader to treatises upon trust for a detailed discussion. Examples of trust held invalid, bequeathed to executors and to successors to be by them distributed by such persons, societies, and institutions as they may be considered most deserving, and held to indefinite and invalidate as a charitable trust, and then there's case sites to support that. It goes into some other things too, but I think we'll go back into the text. Next section, 1026. Certainty or uncertainty of trustee. Certainty or uncertainty of trustee. Charitable trusts also differ from private trusts in another very important feature. It is settled as a part of a complete system prevailing in England that not only may the beneficiary be uncertain, but that even where the gift is made to no certain trustee, so that the trust, if private, would wholly fail, a court of equity will carry the trust into effect, either by appointing a trustee or by acting itself in the place of the trustee. That is, by establishing a scheme for accomplishing the design of the donor as though the legal title had vested in a certain trustee. This result may happen in various modes. In one class of instances, the same rule is merely applied, which would be invoked under the like circumstances to regulate the administration of a private trust, where a testator has expressly purported to give the property to a trustee for any cause the appointment fails, the charitable trust will still be enforced. The doctrine, however, goes much farther than this simple rule, which does not permit a trust otherwise valid to fail for want of a designated trustee. It also applies where the property is given to a person or body incapable of taking and holding it in perpetuity, or to a body uncertain, indefinite, and fluctuating in its members, such as an unincorporated society, or a body not in legal being, as to a corporation not in existence, and even where there is no person or body indicated as the recipients of a legal title. But the property must merely direct it to be applied to some designated charitable purpose. There's the intent. There's the formation of the trust right there. But the property is merely directed, or thought up to be, applied to some designated charitable purpose. That's when the trust is formed. Back in the text, for the performance of which direction might and often would necessarily create a perpetuity. Footnote 2, it says, the following are some of the cases which this doctrine is either applied or discussed to a body not to an existence. Okay, case I support that. Bunch of them. And then it says there is a fundamental divergence between the two classes of American decisions upon this question. In some states in England, the English doctrine is stated in the text is adopted, except so far as it is enlarged by the further and distinct doctrines of Cyprus. And in others, charitable trusts are sustained in the enforcement only when the legal title to the property is given by the donor to a certain trustee competent to take and hold in perpetuity. Now remember, I said there's two theories on that. The more modern theory is it's the formation, is it the intent, which was just expressed a little bit in the previous paragraph. So if the trust is created one, the following cases are given simply as examples. Check them out. Back into the text. This is one of the most important points of distinction between charitable and private trusts, for it is certain that, at law, and independently of the particular doctrine of equity on this subject, gifts to charitable uses without a certain and competent trustee to take hold of the legal title as to the unincorporated and fluctuating society would be wholly void. The doctrine, however, is rejected by the courts of several American states which admit the existence and validity of charitable trusts only in cases where the property is given to a certain and competent trustee. So there's back and forth, one way or the other. Next section, 1027, Doctrine of Cyprus. In administering charitable gifts, the English courts have leaned so strongly in favor of sustaining the trust, even when the donor's specified purpose becomes impractical, that they have invented at an early date and have fully established the so-called Doctrine of Cyprus. The doctrine may be stated in general terms as follows. Where there is an intention exhibited to devote the gift to charity and no object is mentioned, or the particular object fails, the court will execute the trust Cyprus and will apply the fund to some charitable purposes similar to those, if any, mentioned by the donor. If the donor declared his intention in favor of charity indefinitely without any specification of objects, or in favor of definite objects which happen to fail from whatever cause, even though such cases and particular mode of operation contemplated by the donor is uncertain or impracticable, yet the general purpose being charitable, such purpose will, notwithstanding the indefiniteness, illegality, or failure of the immediate objects, be carried into effect. Says footnote 1. In the following cases, this doctrine is defined, discussed, and applied and illustrated. A bunch of case sites to support that. Back in the text, in the first kind of cases where the donor has specified no object, the court will determine upon some scheme which shall carry out the general intention, and in the second kind where the donor specified object fails, the court will determine upon another object similar to that mentioned by the donor. The limitations upon the generality of the doctrine seems to be settled by the recent decisions, and where the donor has not expressed his charitable intention generally, but only to providing for one specific particular object, and this object cannot be carried out, or the charity provided for ceases to exist, where the gift takes effect, then the court will not execute the trust, it wholly fails. The true doctrine of Cyprus should not be confounded, as it sometimes is done, with a more general principle which leads courts of equity to sustain and enforce charitable gifts, where the trustee, object, and beneficiaries are simply uncertain. There is a radical distinction between the two, although the doctrine of Cyprus may be to some extent an expansion or enlargement of the other principle. Footnote 3. So some of the cases in which the court has professedly relied on the Court of Cyprus, which are cited in illustrations of it in preceding notes, seem to be nothing more than instances in which the trusts with uncertain trustees or objects have been sustained. The suggestion of the text is not merely verbal, it has a practical importance, and in this country, it shows that the courts of American states which have utterly rejected the doctrine of Cyprus have made certain sustain and enforce charitable trusts which are simply uncertain in their objects or their trustees, and still be certain with the general position which they have assumed. Back into the text. In the great majority of American states, the courts have utterly rejected the particular doctrine of Cyprus as inconsistent with our institutions and modes of public administration. Sure, that's public policy. Mob rule. Back into the text. A few of the statutes have accepted it in a modified and partial form. Footnote 4, which states it has generally been said that the doctrines of Cyprus and the power to enforce it belong to and result from the executive authority held by the English Chancellor as a representative of the Crown in its character as parens parenti, and are not a part of the judicial functions possessed by the Court of Chancery. While in the United States the courts are clothed with judicial function only, the prerogative belongs to the parens parenti being held by the legislatures. It may be doubted, I think, whether the view is entirely correct. See Starkweather versus American Bible Society and a few other cases. Back into the text. Next section, 1028, origin and extent of the equitable jurisdiction. Such being the general nature and charitable trust, nature of charitable trust, the origin and extent of the jurisdiction over them remains to be examined. The question is one of practical importance in England, since the jurisdiction is there exercised as though it were entirely derived from the statute of charitable uses of Elizabeth. The question, however, becomes of vital importance to this in this country, is absolutely fundamental, since the statute of Elizabeth was Freudian slip there. Since the statute of Elizabeth was or has been held to be enforced in but a few of the states, the opinion at one time prevailed that the particular equitable jurisdiction over charities, except in cases where trusts valid by the ordinary rules of law and equity were created, was derived solely from the statute. Other English judges have maintained the opinion that the jurisdiction in its full extent was possessed by the Court of Chancery by virtue of its general powers, and that the statute had only the effect to regulate that jurisdiction and to define more distinctly the classes of objects which are charitable. This conclusion has been sustained and even demonstrated as correct by the research of the English Record Commissioners. Footnote 3. The question has been repeatedly passed upon by the American courts. Whenever the system of charitable trust has been accepted at all, it has generally been held that the jurisdiction belongs to equity as a part of its ordinary authority over express trust and is not referable to its origin to the statutes of Elizabeth. This conclusion was necessary to support the jurisdiction in a great majority of the states, since that statute has not been adopted as part of their local legislation. Let's go one further. Let's go to the conclusion that the jurisdiction comes from God. And the chancellor was supposed to be the consciousness of the king who was representing God in principles and doctrines of equity, which was administered as being law. And if you didn't do it, you fell under the judgment, and you fell under the law being the statutes, the codes, the Ten Commandments. It's all God's law. But if there is no righteous law in existence today, then that's not God's law, because it's not fair and just, and it's not done for the benefit of love your neighbor as yourself. Next section, 1029, Charitable Trust in the United States. With regard to the extent to which the charitable trusts have been adopted and the jurisdiction over them exercised in the various states, there is the utmost conflict of judicial decision. Conflict. Plead the conflict. It seems possible, however, without attempting any strict comparison of the cases or any minute classifications of the rules, to arrange the different states according to three general types, which shall represent with reasonable accuracy the certainty in the existing condition of the law on the subject of this country. This section is important. The first class. This class includes those states in which charitable trusts have been abrogated or not adopted. Footnote 1. Says the accepted instances authorized by the statutes are generally cases where corporations may receive and hold property in trust for some object which is charitable. The states constituting this class are the following. And we won't go over them, but look them up if you want to know which ones they are. Back into the text. Either from a statutory abolition of all uses and trusts with a few specified exceptions, or from the general provisions of the law against perpetuities, or from the general policy of the state legislation, charitable trusts which do not exist at all, except where they are merely the express private trust permitted by the law, or except in those particular instances authorized by statute. The equitable system of distinctively charitable trusts is abandoned. Second class. This class includes a large portion of the states which the charitable trusts exist under a somewhat modified and restricted form. Footnote 2. The following states are placed in this class, but there is a great diversity in the particular rules prevailing in the different states, and only a general resemblance in their decisions. And I'm not going to read through the states. Check them out. Back into the text. There is not a little divergence in the views maintained by the courts of various states composing this class, and a few of them, the statutes of Elizabeth, is held to be in force, or in similar, it is not to be enacted. The majority of them, the doctrine of charitable trust as a part of the ordinary jurisdiction and fluctuations of equity, has been accepted in a modified and limited form, such as trusts are upheld when the property is given to a person sufficiently certain and the object sufficiently defined. With regard to this element of certainty in the trustee and the object, there is much diversity of decision. The doctrine of Cypress is generally rejected. And third class, this class includes a very few states which have accepted the doctrine in the full extent. Footnote 3. Talks about, Massachusetts, the doctrine is freely and fully accepted, and the rule of Cypress is enforced. And then case cites to support that. back into the text. The states composing this group have not even totally rejected the doctrine of Cyprus, although they do not apply it so freely and under such extreme circumstances as would be done in England. The general system seems at least to be so far adopted and that when an intention to give property to charitable uses is clearly manifested, but the disposition is uncertain and indefinite, either as to the trustee or as the objects and beneficiaries, the trust is upheld or defeated upon the same principles as those which would be followed by the English courts. That takes us to Section 5, trust arising by operation of law, resulting, and constructive. Operation of law, number 1, resulting, and 2, constructive trust. Starting out in it's an analysis in Section 1030. So we'll stop there. We'll pick up next time on Section 1030, the general nature and kinds, in a new section. Section 1030, we'll pick up there next time. That's on page 240 in the PDF or page 2333 in the book. Section 1030, we'll pick up there next time. So press star 8 to get in line for the question and answer. Star 8 to join the Q&A. If you have a question, press star 8 to raise your hand. State your name, where you are from. Questions, anyone? Press star 8 to raise your hand, get in the queue line. Star 8, anybody? Questions? Star 8, anybody? Question? Star 8, push star 8 to raise your hand for a question. Star 8, anyone? Question? Star 8, anybody? Question? Press star 8. We'll wait a little bit, and we'll count them down if we're not. It'll be a short night again. Star 8, anybody? Star 8, going once. Star 8, anybody got a question? Star 8, going twice. Star 8, anybody? Question? Last call. Last call. Star 8, going 3 times. Okay, that's it. We'll call it a show. I'd like to thank everybody for coming and listening to me, and we'll catch you next week. Same time, same channel. Night all.